It's a case unlike any other. Karen Reed accused of the murder of her Boston police officer boyfriend, John O'Keefe. At her first trial, prosecutors painted a picture of Karen Reed running over John O'Keefe in a jealousy-fueled rage. But the jury wasn't convinced, and they deadlocked. Now there's a new prosecutor who says he will not use some of the evidence connected to Reed's alleged jealousy. Will there be a change in approach? And will prosecutors focus more on Karen Reed's alleged drinking that night? Tonight, we take a closer look. In Maricopa County, Arizona, the latest murder trial for the doomsday cult killer Lori Daybell. She's accused of conspiring with her dead brother Alex Cox to murder her fourth husband, Charles Vallow. Opening statements are scheduled for Monday, and Lori will deliver her own as she continues to represent herself. What should we expect from the convicted child killer? But first, in February of 2022, Taylor Schabusiness, a 27-year-old from Wisconsin, committed a gruesome murder that shocked the nation. After using methamphetamine, she and her boyfriend, Shad Therion, engaged in sexual activity during which Schabusiness strangled him to death. Following the murder, she mutilated and sexually abused his corpse, decapitating him and dismembering his body using a knife. Schabusiness expressed to investigators that she enjoyed the act and questioned if they knew what it was like to love something so much that you had to kill it. In September of 2023, she was convicted of first-degree intentional homicide, third-degree sexual assault, and mutilating a corpse, resulting in a life sentence. Now, Schabusiness is back in trouble for an alleged attack while in custody and was back in court today. And once again, Schabusiness was out of control and had to be subdued.
I'm Vinnie Politan. Thank you so much for joining us tonight here on Closing Arguments. We have a lot to get to this hour, and I want to go back in time a little bit to remind you of some of the defendants that we've covered here on Court TV who have had trials that we've seen, defendants who were very unpopular. There was one who was obsessed with her victim. Her name's Jodi Arias. It was kind of like a fatal attraction case. The trial lasted months, and I remember during that trial, Jodi Arias became public enemy #1 because of what she did and how she did it and why she did it. A woman who was just obsessed. If I can't have Travis, nobody can have him. And people looked at her at the time and said, wow, there's something wrong with her, right? There's something wrong with Jodi Arias. And people understood that, and people sort of gathered that from watching her, listening to her testify over the course of a month. She garnered a lot of hatred and a lot of opinions about her. Very few of them, very few of them positive. Then there was someone who was hated more than her, the most hated woman in America. I don't even have to say her name. And that was at the time in her trial. Now, she wasn't convicted of the top charges that she was charged with, but that didn't stop people from having an opinion about her and how much of a villain she became. I remember outside the courthouse, the people that were there demonstrating with signs and chants how much they did not like this one-time mother whose child was found dead, rotting in the woods around the corner from her house. And because of the case, the investigation, the story, everything else, people garnered an opinion about her, and they did not like her one bit. And a lot of people found her vile and dangerous as well. Then there was one, you go back even further, Eileen Wuornos, the monster. She was a serial killer. She was scary. She was scary. Just walking into the courtroom, you may have seen the movie, maybe you saw the trial on Court TV, maybe you saw her in the courtroom in Court TV, but she had this certain presence about her that was just a cold-blooded, callous serial killer. And of all the female defendants that we've covered through the years, I think for most, she was the one that was like, wow, let me back up a little bit, right? More so than the most hated woman in America, more so than that obsessed fatal attraction Jodi Arias. Because in those cases, you looked at them and you said, okay, it was a single action, right? And then you looked at this woman, serial killer, extremely dangerous. And for me, she was kind of top of the food chain in terms of the scariest female defendants I've seen on court TV. That was until we met Taylor Schabusiness, who is clearly the scariest defendant. Doesn't matter about the gender. She is like the scariest defendant I've seen at court TV. And when I say scary, it's based on two factors. I'm looking at her as what she did to get into trouble, and then what she did after she got in trouble and was arrested and made these court appearances, and the way she acted. And you look at her and what she's done since being incarcerated as well. To me, makes her really the scariest defendant of all that we've covered. And there have been some bad ones, Jeffrey Dahmer included. But Dahmer, once he got caught, that was it. It was over. Taylor Schabusiness is not ending. Let me show you what happened today. She was back in court today for an attack that allegedly took place after she was in custody. So now she's brought back into court. She's got a lawyer at the table. Take a look.
And Judge, it sounds like just one witness. We're asking for sequestration, but that may be a moot point.
All right. It is one witness, Your Honor. We're off the record.
I mean, you saw her lawyer. The lawyer was almost expecting it, right? It's at that point. But as soon, and you could tell by watching, as soon as she made that, she gave that little look with her eye, out of the corner of her eye, you knew something was happening. She's completely unhinged. Lack of control and danger. Let's watch it. Can we watch it one more time? Let's watch it one more time if we can.
And Judge, it sounds like just one witness. We're asking for sequestration, but that may be a moot point.
All right. It is one witness, Your Honor. We're off the record.
Courtroom deputies were ready. You saw how quickly they pounced. They knew this was possible. They absolutely knew this was possible. Why did they know? Well, we've seen it before in a courtroom. Let's go back to 2023, when she was first arrested. Take a look.
Stop it. Stop it.
Now, the main difference here is you see there's just one bailiff there because they did not know at the time. Now they know. Now they know how dangerous she is. So what's going on here? How do we handle this? How can our system handle this? Let me bring in an expert. Psychiatrist, forensic specialist, and medical health expert, Dr. Yalda Safai is with us. Doctor, thank you so much for joining us. The allegations against her, what she was convicted of, absolutely horrific. We understand that. But her behavior since also completely unhinged. What is going on here? What is this the wiring that some people just have? Do you think something else could be going on here?
Sure. Actually, her behavior is not completely abnormal from an inmate. I work in a jail setting, and I see this kind of behavior all the time. Inmates attack correctional officers or their lawyers or sometimes their doctors all the time. So the thing with inmates is a lot of them are in the predicament that they are because they have problems with impulse control, right? Add that to the stress of being incarcerated, to being on trial, it really makes their impulse control even that much worse. So something as small as what the lawyer said in this case could trigger them and set them off. But I don't know her, but to sum it up, I've seen this kind of behavior in inmates all the time. The difference is with her, most inmates try to keep it together for court while they're on trial to look good in front of a jury. With her, it doesn't seem like she wants to even try to keep it together in court. But to answer your question, this kind of behavior happens a lot in a jail setting.
Now, we go to what she was accused of. She's accused of an attack while being incarcerated, right? So they've got to keep everyone safe, the people that work there. You've got to keep other inmates safe. So how does the system deal with someone like this who has already murdered a sex partner, decapitated that person, engaged in sexual activity after murdering that person, has attacked 2 of her lawyers in 2 different cases. So what do they do?
This is very tricky. From my experience in working in jail setting, you want to balance the safety of the officers and everybody that's dealing with the inmate versus the right of the inmate. Using excessive force, keeping them in isolation for too long violates their rights. But at the same time, you want to try to keep everybody safe. So it becomes a very delicate balancing act that it's up to the county and up to the jail that she's incarcerated at to try to balance. But it's a very difficult situation for everybody, unfortunately. And I see this in the county I work in right now, in the jail I work in. We're constantly battling this issue. How to keep everybody safe versus not violate the rights of an inmate. Because at the end of the day, they do have rights. They have been convicted or they have been alleged to do certain crimes. But at the end of the day, they're humans and they have rights. So you really want to it's a delicate balancing act. But good question.
So I want to play from her police interview where she discusses what she did.
What did you do with the head?
The head, I put it in that bucket, that black bucket.
Black bucket?
With the blanket on top.
Okay. And then where'd you leave it?
Leave the head? The head's still in the bucket. It's right by the stairs.
By the stairs? Okay. Okay. How did you dismember his body then?
Knives.
With what?
Knives.
Knives? Just more than one knife?
About 4.
Where'd you get those from?
Kitchen.
Is this, when you're dealing with someone who has done this, right? This is like horrific. She did this to a friend of hers. It wasn't like it was an enemy. And now you're locked up. There's other inmates here. There's potential ability to get weapons from time to time. I mean, that's always possible, or you could turn something into a weapon. Does someone like this, who has a history like this, get the special attention? Will they get some level of medication to sedate them? How does that work? Does any of that come into play? Because I know there's inmates that have done all different things, but sometimes, there's a motive for the murder as opposed to someone who just can't control themselves and kills.
Sure, great question. And I'm going to tell you how things run in our county jail. People who are at high risk of violence, who have attacked other inmates, have attacked correctional officers, have a known history of violence, are usually put in a different color jumpsuit. They're usually put in a red color jumpsuit. And that's because they do that so everybody is aware, the people that work there, to have pay extra attention to these people because they have a tendency for violence. Anybody who has been accused of murder or rape, these are serious crimes, tends to go see a psychiatrist while they're in jail, just to make sure there's nothing mentally going on. If there is any history of mental illness or any acute psychosis or mania or anything that's making them act out and be violent, for the doctor to be able to properly diagnose that while they're in jail and put them on medication. So most people go through this process when they're in jail, especially a case like this, high profile cases, people who have committed heinous crimes go through this process of seeing a psychiatrist while they're in jail.
Dr. Yelda Safai, appreciate your valuable time. Thank you so much.
Thank you.
Let's bring in our think tank. Joining us tonight, former senior homicide prosecutor and founder of Villona Law, Bernardo Villona. Also with us, criminal defense attorney, former prosecutor Brian Watkins, and the attorney who represented Johnny Depp in his defamation case, fellow of the American College of Trial Lawyers, Ben Chu, is with us. Okay, so I want you to take a listen to what she's in trouble for now, okay? It's not for the murder and dismemberment and post-murder sexual assault of her friend. This is the detective testifying about what she allegedly did.
Taylor had indicated that there was a staple in her arm and a request was put in for a nurse to remove it. One of the correctional officers at Tachita, a female sergeant, was tasked with bringing Taylor down to the nurse's office so the nurse could remove that staple. While in the nurse's office, Taylor began giggling, and then a short time later, when the nurse was in the process of removing the staple with the tweezers, Taylor lunged initially at the nurse. Then the sergeant pushed the nurse out of the way and began to try to gain control of Taylor to get the nurse out of the way. And in the process of that, metal tray from the nurse's room was grabbed by Taylor. The correctional officer believes she was struck in the head by that, does not believe she was concussed, but then reported in the course of struggling to get Taylor under control, received bruising to her ribs and pain in her arm.
Okay, Bernardo Villona, a couple things from that clip, right? One, the allegations. She's got a staple in her arm. How did that get there? And then she goes to the nurse. The nurse is trying to help her, and she lunges at the nurse. Now, when it's time for her preliminary hearing, she is not permitted in the courtroom. They've got her literally locked down in the chair in front of the camera. So what are we going to do with this? What is our system of justice going to do with this latest case against Taylor Schabusiness?
And it's an issue, and it's an issue, Vinnie, because usually in front of a jury, if this does go to a jury trial, is that you want to have the appearance that the person is not in custody, that the person doesn't have handcuffs, that the person doesn't have their legs shackled, because you want to give the presumption of innocence. But you also want to balance off the safety of the people in the courtroom, the safety of her own attorney, the safety of the court officers. So it's a huge balance here. I mean, I wouldn't want to be her attorney. I will be honest. I wouldn't take on a case like this because no one's going to put their life on the line for a person like this who you know is a threat and you know that actually has gone after her attorney on prior occasions.
You know, Brian, this is almost like time to fire up the old Sacco and Vanzetti courtroom where you put the defendant in a cage in the courtroom. But we can't do that. So what do we do with this, Brian? What are we going to do with this case, with this defendant? I mean, every time she's in a courtroom, she's attacking her own lawyer.
Yeah, but technology is taking care of it all. So what you're going to do is you're going to put her in another room, and she's going to be on Skype or Zoom. She's going to be on video. And the court's going to give a limiting instruction saying, hey, we have some issues. She's going to be seen on video, and she's going to be sitting there on the video, not actually live in the courtroom. So technology has really helped us in that aspect. We don't have to have her sitting there chained up like Hannibal Lecter.
Well, she's chained down to this chair on camera. Do we do that, or do we just zoom in so the jury only sees a big head?
Yeah, you just give her the good face shot.
Ben Chu, this is dangerous. I mean, this is extremely dangerous for that nurse who had tweezers. If she had gotten her hands on the tweezers, who knows what happens. We understand cruel and unusual punishment. You want to take care of people when they're incarcerated, but this is a ticking time bomb. What do we do?
Absolutely, and I do agree that there are technological means to take care of it. There are also devices you can put on the defendant and code words you can use so when the judge issues that word, the defendant knows that he or she needs to stop. I've seen that done before.
Bernard, you know what's amazing is her attorney, as we watch him here, barely even flinches.
Right.
Barely,
He saw
I'm
it
like,
coming.
He knew it was coming. And he puts
Yeah,
his arm.
he
What am I
saw
going
it
to do?
coming.
What am I going to do here? He's off the case
saw it
now.
coming.
He's off the case.
Yeah. Absolutely. Absolutely. You know, it's funny because sometimes you have those clients where you see those defendants in court that you're like, well, that's a huge safety risk. And you can see the attorney sometimes know that it's coming and they start stepping away and there's a huge distance between the client, the defendant, and the attorney. So, you know, you read the courtroom, and if you're in the courtroom long enough, you can tell which cases are going to be the problem ones or which attorneys actually fear for their own safety based on the client that they have.
She is literally the most dangerous. And I think part of the danger is, Brian, is that she's so unpredictable. 1 minute, as was described, she's giggling. The next minute, she's gone. How do we even get someone to be able to evaluate her competency? Like, I don't know if you could put someone next to her if she is not restrained.
Sure, she definitely needs to be restrained, but it does bring up a great point about her competency. I mean, obviously, she has some mental problems. I mean, nothing was said in that courtroom that would trigger a normal person to act violently. It wasn't like she was attacked in any way or anything like that. So we have some mental issues going on here, obviously, you know, and that needs to be addressed. But the problem is it can't be addressed it won't be addressed at my expense, and it won't be addressed at this lawyer's expense. And she needs to be locked up, and her case may be harmed if a jury happens to surmise that, hey, she's shackled for a reason. Maybe she is crazy and violent. Well, that's on her. I mean, you can't do actions and then sit there and cry that you're punished because people are judging you on your actions.
Yeah, it just seems, Ben, that the safety of people who work at the jails and the prisons, the safety of the lawyers, the safety of the deputies, every time there's an outburst like this, someone can get hurt. And she's in there for life already. Do you think prosecutors should consider just moving on from the case and she's not getting out of prison, we know that.
Yeah, Vinnie, I absolutely agree with that. In my lay opinion, she's crazier than an outhouse rat, and I think they should just let it lie.
If she wasn't already doing life, I wouldn't consider that, but I think it's almost unsafe for everyone involved. Anyhow, great news, Think Tank staying with us. We've got a lot more to get through this hour. Up next, Lori Daybell. Lori Daybell getting ready to deliver her own opening statement on Monday. Plus, coming up next hour.
Tonight on Vinnie Politan investigates the disappearance of mother of 5, Crystal Rogers. She vanished without a trace, but now 3 men have been arrested, and 2 hairs found in her car may loom large in the upcoming trials.
Join Court TV's Vinnie Politan with the latest and breaking true crime stories.
Now, let's look at the other side of all of that.
Vinnie Politan Investigates. Tonight, 9/8 Central, only on Court TV. Before next week's season premiere of Interview with a Killer, relive the most shocking moments.
Tell me what happened that night.
Interview with a Killer Marathon. Sunday at 7, only on Court TV.
On your car insurance.
I ordered that you don't have to wear the leg restraint, but that you do have to wear the rack belt, because that is not going to be visible to the jury. The leg restraint's a little more cumbersome and visible, and since you're representing yourself and you're going to need to approach the podium and those sorts of things, I ordered the removal of the leg restraint. You will, though, wear the rack belt. And then I said it's up to the sheriff's office if they want to. They can position a couple deputies in the back if they want, additional deputies.
Well, their recommendation was that you wouldn't have to use the belt at all if they had the armed guard.
I read their response and their recommendation, and that's my order.
So what is it exactly?
That you have to wear the rack belt, but not the leg restraint.
And that they will or will not have armed guards?
It's up to them.
Okay.
Lori Daybell is representing herself, which means at some point she's going to stand up and deliver an opening statement. But as you heard there, She's not just going to be able to walk around freely inside that courtroom. She's going to have the belt on, where if she acts up, then I guess they activate the belt and then down she'll go. So they don't have a Schabusiness situation. Now, you don't expect that in Lori Daybell's trial, but she is a convicted murderer who will be representing herself inside the courtroom. Take a look here. Here she is complaining to the judge about some of the problems she's been having.
I feel like the state is trying to say, okay, if you want your speedy trial, guess what? We're not going to let you defend yourself. Guess what? You can't have any experts. And guess what else? You can't have any witnesses. You can't have anybody speak in your behalf. So good luck. Have a nice day.
Pretty passionate. I don't know how much sense she's making, but she's pretty passionate. Let's bring back in our think tank, still with us, Bernardo Villalona, Brian Watkins, and Ben Chu. All right, Brian. Monday's the day. Opening statements. You'll see them here on Court TV. Lori Daybell representing herself. Now, she does have experience, Brian. She sat during her own, her first murder trial and got convicted for murdering her children and taking part in the murder of her fifth husband's first wife. What are your thoughts about what you expect to hear and see from Lori Daybell on Monday?
You know, whenever you have a defendant representing himself, it's always a train wreck. People don't understand how hard this job is. I mean, we go to law school. You can't just sit through a trial or watch an episode of Court TV, even though that'd be good for you to do. But you can't go in there and act like a lawyer, okay? The procedure of being a criminal defense lawyer is, you know, the procedures are crazy. And to know them all, I mean, you got to be really good. You got to go to law school and you got to practice for a long time. Even lawyers that have been practicing for a long time don't know it. So it's going to be a train wreck. She's not going to understand the rules of evidence. She's not going to understand what can and can't be said in an opening statement, what's argumentative in an opening statement. You know, a lot of times the prosecutions won't object because it's just going to delay things and the trial will never end. But you need a lawyer. This job is not easy. It's hard. You need a professional. And her representing herself, it's going to be a train wreck. It's going to be delay after delay. You know, she's not going to get her point across. And, you know, they say a person who represents himself have a fool for a lawyer. That's true.
Let me ask you, Ben, how do you prepare for an opening statement?
Well, it takes hours and hours, and it's combing over all of the discovery and trying to develop your themes of the case. I agree, it's an incredibly complex task. And one of the cardinal rules, as you know, Vinnie, and as your panelists know, is that you cannot promise something in opening that you cannot deliver. You have to make sure that everything you say that the evidence will show is evidence that you can actually prove at trial. And I think it's an insuperable obstacle for a layperson to do. It's hard enough for us lawyers.
So, Bernardo, do you think she'll be accusatory, defensive? Do you think she'll be on the attack? And who will she go after? Will she go after her brother Alex? Will she go after the police? Will she attack the victim, her fourth husband Charles? Where do you think she's gonna, what are her themes going to be?
So, Vinnie, I think it's going to be a combination of all of that, because you have to think, because she's a lay person and not an attorney, she's not going to know that she shouldn't be touching certain issues and she should stay far away from certain issues, especially when you're talking about getting ready for an opening statement, because we all know when it comes to trials, defendants do not have to testify. But by her serving as her own attorney, she's on full display. Like, this jury is going to be determining her credibility every time that she opens her mouth. And I think that she's going to open up the doors to so many issues that the prosecution is going to be able to bring in evidence that they normally wouldn't be able to bring in, just because she made the fatal flaw of opening up the door to those issues.
Now, Brian, I don't know if you heard, but there's a lot of men on this jury. A lot of men. It's mostly men. I think it's 13-3 with, you know, 4 people are going to be alternates, but it's predominantly a male jury. Do you think that plays into the way she presents herself in her open on Monday?
You know, I don't know how charming she can be. You know, I mean,
well, she convinced 5 men to marry her.
That is a great point right there. But these jurors know that that's not going to happen here. And she may try to come on and pour on the charm. But I think a juror's going to see right through that, you know?
Yeah, I don't think it's an accident, Ben, that there's, you know, an overabundance of men on this jury. I know the way she's lived her life, the way she's been described by relatives is that if she kind of gets cornered, that's when she gets kind of ramped up. And I wonder if she'll feel that way in her opening statement or if she will attempt to put on the charm, have some of the poise that she exhibited in the Mrs. Texas, I think it was the 2004 beauty competition, where I think she came in 4th.
Vinnie, I agree with Bernarda. I think she may try to show the charm, and as you say, she's beguiled at least five, and to marry her, but I think it's just filled with landmines for her.
You know, Bernarda, she does have access to some products to make herself even more beautiful, apparently, inside the courtroom. I guess that's one card she can play. How much do you suspect she'll lean on her standby counsel?
Oh, I don't think she's going to use standby counsel at all. If anything, to make some comments to standby counsel, but I just don't see her actually having her actively involved in her defense.
Now, the only thing I'll say about a pro se is they do have one advantage. They know the facts better than anyone, and they know the truth. But I don't know if that helps her in this case. All right. Think Tank staying with us. When we come back, another big trial getting ready to start, and they're moving along with jury selection in the Karen Reed case. We're going to take a look at the prosecution tonight and whether or not they are going to sort of adjust their game plan in how they attack Karen Reed.
Under Karen A. Reed's receipt, 1 Tito's, $10, 1 Tito's, $10, 1 Coors Light, $5.
Sustained. I get in touch with Karen again, and I say, Karen, we saw you outside of my sister's.
And what was her response to that?
She told me that she didn't remember going there, and then she started yelling, Jen, Jen. And then she was saying, did I hit him? Could I have hit him?
Now, right there, that testimony from Jennifer McCabe in the Karen Reed trial, important for a couple of reasons for prosecutors, right? On the one hand, the alleged confession, which the first jury didn't buy, but the alleged confession about hitting him. And then, but the other part of it was that she said she didn't remember being there, which goes to a whole nother issue, which is Karen Reed's state of mind that night before and state of potential inebriation, and whether or not she was under the influence and how under the influence was she. Let's take a listen to some testimony now. This is from Massachusetts State Trooper Buchanan talking about the same issue, about how much Karen Reed had to drink.
During that, about 30 seconds or so, what, if anything, of significance did you observe the defendant to receive at that point?
A cylindrical cocktail glass.
And so that would be the second drink, is that correct?
That's correct.
Sergeant, from this particular video, what, if anything, of significance do you observe the defendant receiving during this time frame?
She receives another shot glass beverage and then places that liquid into her tall cocktail glass and stacks the second shot glass into the first shot glass into the first tall cylindrical cocktail glass she had previously received and consumed.
This would now be the fourth drink, is that correct?
That is correct. Once the defendant got drink number 7, the defendant and Mr. O'Keefe walk out of C.F. McCarthy's, the defendant holding the beverage, tall cylindrical glass in her hand.
Okay, so that night they were drinking first at C.F. McCarthy's, and then they went across the street to the Waterfall Bar and Grill take a look. This was a receipt that was part of the first trial. You see a couple bottles of beer there, and that is, I believe, what John O'Keefe was drinking. But also on the bill, which is John O'Keefe's bill, were some Tito's. So is that what Karen Reed was drinking that night? So did she have 7 drinks at McCarthy's and then more at the Waterfall before getting behind the wheel and driving over to 34 Fairview? And the reason I'm bringing this up, and the reason why I think it's important, is in the first trial, the evidence was there, but the prosecution really didn't lean into this aspect of the case. They were leaning more into Karen Reed is jealous. You know, the whole Aruba trip, the Sullivan sisters. Well, the prosecutor's already told us he's not calling the Sullivan sisters. He's not going to talk about what happened in Aruba. And that was all about the alleged jealousy motive. So are they going to lean more second time around into Karen Reed's drinking that night? Let's bring back in our think tank. Still with us, Bernardo Villolona, Brian Watkins, Ben Chu. Brian, what do you think? Are prosecutors going to change their tack? They've already said, we don't plan on calling the Sullivan sisters. We're not going to talk about the alleged acts of jealousy down in Aruba. Is that a signal that maybe they're going to lean more into the allegations of her being under the influence?
Probably. You know, that's one thing about a mistrial. When you get a do-over, the prosecution often changes up its theory. When it didn't work the first time, we'll try something different the second time. And actually, the prosecutions have a very good conviction rate on second-time trials. And I think they learned from the mistakes of the first trial. So if the jury wasn't buying it the first time, why try to sell it again? It's not a product that's very sellable. Let's go with something totally different. And alcohol, I think, is what they're going to lean on.
You know, Bernard, that first trial, it was about the jealousy. They were trying to paint the picture that Karen Reed was jealous and she was thinking that John O'Keefe was cheating on her, and that's why she was so angry at him, and that's why she did it. Can they pivot in this retrial?
I think they can. They're definitely taking a different approach to it. And I think when you deal with alcohol, they can probably say, and what they're focusing on is to say that, look, she probably believes that she didn't do it, but she was so intoxicated that she really doesn't remember what she actually did. So I think they're trying to say that this may be a more plausible argument, more that one that the jury will be able to go with. But I don't know. I don't know. I don't think it's as strong as the cheating angle.
Let's take a listen to Nicholas Rogers from the toxicology unit.
When was the time that's utilized as far as the last drink or time of operation?
The time that was utilized as the last drink, it was at 12:45.
That'd be 12:45 a.m., is that correct?
Correct.
So from your calculations when it came to the minimum with regard to the retrograde extrapolation, what, if any, calculation, what, if any, result did you come from with your calculations as it pertained to the minimum?
So the minimum amount that was calculated would have been a 0.135 gram percent.
And that's essentially recording in a blood alcohol concentration, is that correct?
Correct.
And then with regard to the maximum, what, if any, result did you get from your mathematical calculations in regard to that?
The result was a 0.292 gram percent.
All right, Ben Chu, those are pretty high numbers. 0.13 to 0.29 is what they're alleging here. You know, when this case first happened, when it was first reported, this was what I thought the case was going to be about. Someone drinking, driving, and there was an accident. And that's where the original charges were. That's where the defense originally was talking about in his first interview, David Yannetti, before they uncovered what they believe was this incriminating Google search, how's long to die in the cold. And then before prosecutors turned this into a murder case. So what are your thoughts about the role of alcohol and how each side will play this issue in the upcoming trial?
Vinnie, I think you put your finger on it. I've always thought this case was about alcohol, and I was puzzled by the first trial. And I think the alcohol issue cuts both ways. I understand that being intoxicated is not a defense unless you're talking about first-degree murder. However, I think there are people on the jury who could empathize with her if she had too much to drink and believe that she really didn't know that she had hurt him or not, and there could be some jury nullification. So it may be a better theory and a more accurate theory for the prosecution, but I could see a couple of jurors feeling bad for her.
You know, when you look at the charges and what happened in the first case, Brian Watkins, some of the jurors came forward and they said murder was off the table, the top charge. Leaving the scene of the accident, the bottom charge, was off the table. They were talking about the middle charges, which involve the manslaughter and the involuntary manslaughter, and the lesser included as well. They're debating all of that, trying to come to some conclusion about whether or not her car struck it, but in no instance did it seem that they were debating whether or not it was done on purpose. And here we are in a case where she's charged with murder. The first jury discounted it, but prosecutors are attempting to go after it again. And at the end of the day, it's like the jury came back to where Ben and I were in the beginning of this case, right? Where this is a case that's about someone drinking and driving. Did they or did they not accidentally strike someone? But that's not what the trial's about. It's about a conspiracy where he's murdered inside the home, or she purposely ran him over. And the jury wasn't there.
You know, that's the truth. You know, the problem with it is prosecution doesn't have to prove motive. And in the first trial, they went to prove a motive with all this Aruba stuff and this jealousy. And people get cheated on, and people's relationships go sour, and it doesn't end up in murder. And if you are going to murder someone, you're not going to murder them by hitting them with your car, because you hit somebody with their car, you don't even know if they're dead. They could just be hurt. They're just laying there. So that's not a good way to murder someone. You're not going to murder someone because you think that you didn't even catch him. You think he could be cheating on you. These are far-fetched ideas that the jury didn't buy. Now, what's a non-far-fetched idea is someone gets drunk, hits somebody with a car, freaks out and leaves. That's not far-fetched at all. That's real believable.
Big thank you. Great job, Think Tank. Bernardo Villalona, Brian Watkins, Ben Chu, great to see you. When we come back, I will reveal something else you need to know tonight, plus coming up next hour.
Tonight on Vinnie Politan Investigates, where is Crystal Rogers? She's a mother of 5 who is suspected to be dead, and 3 men have been arrested, including her former boyfriend and the father of her youngest child. What do we know about the suspects? Tonight, we investigate.
Join Court TV's Vinnie Politan with the latest and breaking true crime stories.
Now, let's look at the other side of all of that.
Vinnie Politan Investigates, coming up next, only on Court TV.
Doomsday Cult mom is now lawyer Lori.
She's representing herself
on charges of conspiring to murder her 4th husband.
She said, I can murder you now.
The Cult Mom conspiracy trial begins Monday morning, only on Court TV.
Welcome back. Time to reveal something else you need to know today. Let's take a look at the big board. What do we have for you tonight? The high-profile prosecutor has joined the prosecution team in Idaho in the case against the accused Idaho student killer. Who is he? Well, he's Idaho's former U.S. attorney. He was a federal prosecutor is joining the team. His name is Joshua Hurwitz. He'll serve as a special deputy prosecuting attorney for Latah County. According to a recent filing, the lead attorney is still Bill Thompson, but this is a big move. I mean, he's a big-time guy, very experienced, high-profile stuff. So we shall see. That's bad news for the defense, I'll tell you that. Bad news for the defense. Okay, we need your help. There's a child who's missing. Please take a look at the screen. This is Selena Morgan. Selena is missing from Leavenworth, Kansas since March 26th. Selena is only 15 years old. Here's what you can do. If you look at her, you can see that her hair was dyed burgundy the last time she was seen. So if you see her, pick up the phone, make a call, make a difference. You can call 911, 1-800-THE-LOST, or you can call the Leavenworth Police Department in Kansas. That phone number's on our screen. Let's see if we can get Selena to a safe place tonight.